Just days after burying her beloved husband, Sarah stood on her own front porch, not as its grieving owner, but as an unwelcome stranger. The key that had opened her home for 40 years now refused to turn, replaced by an unfamiliar lock. The events you are about to witness are a dramatic reconstruction, brought to life through artificial intelligence from real, factual accounts. These powerful visuals help us illustrate the profound emotional journey within this story. If you're moved by tales of unexpected turns and human resilience, please consider subscribing to The Forgotten Ones and turning on notifications so you never miss another deep dive. The betrayal was immediate, sharp, and chilling. Her sons, Michael and David, had changed the locks, believing they had inherited the house. This was the crushing consequence, the unjust outcome of a grieving widow being locked out of her own life. They operated under a common misconception that upon their father's death, the family home automatically became theirs. But this explanation, as Sarah knew, was profoundly incomplete. The central question looming was simple yet devastating. How could her own children believe they had the right to lock her out of her marital home, a place she had helped build and cherish for decades? The promise we'll uncover is how a single, overlooked legal document, a house deed, would ultimately rewrite this painful narrative, restoring Sarah's dignity and exposing the intricate, often misunderstood mechanisms of property ownership after death. For years, the house had been theirs, Sarah and George's. It was the bedrock of their family life, the place where memories were forged. They had always assumed a shared ownership, a simple understanding. However, property ownership isn't always straightforward, especially when it comes to the legal nuances of spouses. A deed stating joint tenancy with right of survivorship, or tenancy by the entirety, would have ensured Sarah automatically became the sole owner. But a deed titled as tenants in common means each spouse owns a percentage separately. In such a case, the deceased's share doesn't automatically go to the survivor. It must pass through probate, potentially to children or other heirs, depending on the will or state laws. Sarah's sons, Michael and David, firmly believed their father's passing meant George's share now belonged to them. They were convinced the property would be tied up in probate, and they, as the direct heirs, had the ultimate say. This mistaken belief drove their actions, changing the locks, effectively initiating an illegal lockout. This is known as a self-help eviction, and it's against the law in most states, even for family. Michael, the elder son, had even referenced the legal complexities he'd vaguely heard about from a friend who dealt with an estate in North Carolina where a surviving spouse might only get a life estate, not full ownership. But the truth of Sarah's situation was far simpler and far more powerful. The house deed, the ultimate proof of ownership, held a secret that her sons had completely overlooked. Sarah remembered a conversation with George years ago, a deliberate decision made during a period of financial planning. They had wanted to ensure her security, no matter what. She recalled George specifically mentioning the phrase, right of survivorship, when they finalized the paperwork for their home, 123 Maple Street. A detail that now, in her darkest hour, became a beacon of hope. In her grief, Sarah found a renewed resolve. She needed to find that document, the proof that would challenge her son's assumptions and restore her rightful place. The search began amidst the echoes of a life shared, through boxes filled with forgotten mementos and faded memories. Each item a reminder of what she stood to lose. Finally, tucked away in an unassuming box labeled Household Bills, 1980s, she found it, a thick, legal-sized envelope, slightly yellowed with age. Inside, nestled amongst old utility bills and tax receipts, was a certified copy of the deed to 123 Maple Street. Its formal language was intimidating, but her eyes immediately found the crucial phrase. There it was, clear as day. George and Sarah Miller, joint tenants with right of survivorship. This meant the house bypassed probate entirely and automatically transferred to her upon George's death. This single phrase, often misunderstood, is a powerful legal mechanism. It ensures that upon the death of one co-owner, their interest immediately passes to the surviving co-owner without the need for court intervention. This was the undeniable proof. Sarah owned the house, solely and legally. Her son's actions were not just unkind, they were unlawful. To confirm, she knew she could visit the county clerk's office or search online using the property address on the local tax assessor's website to find the assessor's parcel number, APN. Most counties, in fact, maintain public records, often accessible online. A certified copy without a watermark typically costs a small administrative fee, perhaps $1 per page, directly from the county clerk. The next step was clear, confronting her sons with the unvarnished truth. This was not just about regaining access to her home, but about reclaiming her standing, her dignity, and her peace of mind. The sons, Michael and David, had not acted out of malice, but from ignorance and perhaps a degree of entitlement. They genuinely believed they were protecting their inheritance. Crafting these stories, from deep research into property laws and family dynamics to meticulously reconstructing each cinematic scene, is an immense labor of love. Your engagement is our only payment. A simple like and watching until the very end tells us this content resonates with you, ensuring these important narratives reach even more people who need to hear them. Their father, George, had passed away without a formal will, compounding their misunderstanding. In the absence of a will, state intestacy laws dictate how assets are distributed, not family wishes. And in many states, even if a spouse's name isn't on the deed, they may still have significant rights, like a homestead right in Texas protecting against eviction, or a life estate interest in places like North Carolina. But in Sarah's case, the joint tenancy with right of survivorship negated all these complexities, making the house unequivocally hers, outside the purview of probate or intestacy laws. The emotional toll of family betrayal is immense. Being excluded from one's home by one's own children can lead to profound feelings of rejection, anger, and a deep sense of injustice. This kind of act, often termed posthumous abuse, can shatter basic assumptions about trust and security, leaving the victim questioning everything they thought they knew. Sarah, armed with her deed, knew she had to approach this with legal clarity, not just emotional appeal. She sought counsel from a local attorney, Miss Evelyn Reed, known for her expertise in elder law. Miss Reed immediately recognized the strength of Sarah's position. "Mrs. Miller," she began, "your deed is unequivocal. This property bypassed probate entirely. Your son's actions are unlawful." The lawyer explained that an executor's responsibility is to safeguard estate assets, but they have no right to interfere with property owned in joint tenancy with a surviving spouse, as ownership passes directly. Removing a legal occupant, even a family member, requires a court process. Self-help lockouts can lead to claims of harassment, fines, and even police intervention to restore access. The legal implications of changing locks on a co-owner are severe. In states like North Carolina, it's considered an unlawful ouster, allowing for court remedies to restore access. The lawyer advised Sarah to write a formal letter to her sons, co-signed by Miss Reed, outlining the legal reality and demanding immediate access to her home. This official communication would remove any doubt about Sarah's legal standing and the unlawfulness of their actions, forcing them to confront the truth head-on. Michael and David received the letter the following morning. The official letterhead and the stark legal language immediately disarmed their previous confidence. They had believed they were acting within their rights, but the clear, concise explanation of joint tenancy with right of survivorship from Miss Reed's office shattered that illusion. They had assumed a will was paramount, or that without one, intestacy laws would put them in control. But common misconceptions about inheritance often lead families astray. Many people mistakenly believe their spouse will automatically inherit everything, or that living on the property grants ownership. These are dangerous oversimplifications. The sons, now realizing the gravity of their mistake, felt a wave of shame and regret. Their attempt to control what they thought was their father's legacy had deeply wounded their mother. The incentive here was not just financial, but about a perceived inheritance, a legacy they felt entitled to. They had followed a path paved with assumptions, not facts. Who pays the price for these misconceptions? The grieving survivor, like Sarah, who faces not only the loss of a spouse, but the additional trauma of family conflict and legal battles. The cost isn't just emotional. Legal fees for contested wills or property disputes can deplete an entire inheritance, as some estate lawyers have sadly witnessed. The psychological impact of such betrayal can lead to anxiety, depression, and a profound difficulty in trusting others, fracturing family bonds that may never fully heal. But an honest counterpoint must acknowledge the complexity of grief. Sometimes, children act rashly, not out of malice, but from their own pain and fear of losing control or following poor advice. The sudden loss of a parent can expose underlying family tensions or unwritten promises, leading to disputes, especially in blended families, as seen in the Henry Stamford Thirsk case in 2022. In that case, the wealthy farmer's widow, Sarah Jane Thirsk, challenged her late husband's will, which had provided her with a £5 million legacy, but restricted her occupancy of the marital home. Even with a will, disputes arise. Sarah's sons, confronted with indisputable legal proof, had no choice but to back down. They sheepishly returned to the house, holding a new set of keys. Sarah, dignified and resolute, accepted the keys. The house was hers again, legally and emotionally. The act of changing the locks had been a painful chapter, but the truth of the deed had prevailed. Her dignity was restored, not through conflict, but through the quiet power of a meticulously worded legal document. The house, once a symbol of dispute, became a testament to enduring love and foresight. The sons locked her out after funeral they didn't know she still owned the house. This story is a stark reminder that true ownership transcends sentimentality, rooted instead in the precise language of law. This journey into the heart of family, loss, and legal battles reminds us that truth always finds a way. If this story touched you, please subscribe to The Forgotten Ones, hit the notification bell, and give this video a like. Every single one of your gestures helps these vital stories of human experience reach a wider audience. Thank you for watching.